Yes, you've had a long morning, haven't you?
Yes, quite busy.
Yeah.
Yes. So we are ready?
Yes, well, can I just give the quorum for those attending before you? For the petitioner, another colleague, Mercy Itemi, and and Adoni for the petitioners, and for the third respondent, another colleague, Henry Mino. For the fourth respondent, another colleague, Mr. Mbatia, who's here. My another colleague, Elizabeth Manyango, and myself, for a job will here for the first and second distributors. Ms. Akeno is here for the Attorney General.
Who is that, sir?
Ms. Akeno.
It's Miss Akuno.
Akuno.
Appearing already of the Registrar Council, appearing together with Miss Beatrice Akuno for the 6th, 7th, 8th, and 9th interested parties.
6, 7,
8th and 9th interested parties.
yes.
No, there are various interested parties, but I'm afraid I haven't got the quorum for them. Perhaps they could introduce themselves if they're here.
Just a correction on the petitioner's representation. Myself and Ms. Kadoni represent all the petitioners apart from the 47th petitioner. Ms. Kagori entered a change of advocates for the 47th petitioner, Ms. Kagori, and today I'm holding her brief. Thank you.
In accordance with the direction that your Lordship had given some time ago, we're here for purposes of highlighting the submissions in respect of the petitions applications dated the 11th of April and the 27th of April, 2023. The 11th and the 27th. 2023 in respect of an application for citing the respondents for contempt of court. far as I know, the parties, that is the petitioners and the respondents, have filed their respective papers in support and in opposition to the applications. And they have also filed written submissions in that regard. And today we were supposed to come therefore highlighting.
Yes, my lord, I confirm that that is the position. We are ready to highlight the submissions with relation to the two applications. Because there are two applications, I was wondering whether it would be useful for the court if all the parties ran through what they have filed, just for clarity purposes, and when the court retires, can check whether they have all the pleadings.
That has been done. Everybody has confirmed that the documents are in order. Did you have opportunity today to confirm?
No, I think let's just state what we have filed. It's a party's duty to make sure it's on record, but at least for the court's attention, it would be important for us to say what we filed before we start the highlighting. If that's all right.
Okay.
All right. So on our part, with regards to the application dated 11th April, we have that application is accompanied by a supporting affidavit sworn by Mustafa Mukhtar. Mukhtar is M-U-K-H-T-A-R, sworn on 11th. Mukhtar. Mukhtar is M-U-K-H-T-A-R. Mukhtar. Sworn on 11th April 2023. A supporting affidavit sworn by Teslin, T-E-S-S, Lin, L-I-N-E, Tony, T-O-N-I, Kayewitz, K-I-E-W-I-E-T-S. Teslin Tony Kayewitz, also sworn on 11th April. A supporting affidavit by Kiana Monique. Kiana, K-I-A-N-A. Monique is M-O-N-I-Q-U-E. Arense, A-R-E-N-D-S-E. Also on 11th April. And a supplementary affidavit sworn by Kiana Monique on 22nd May 2023. Our submissions for that application are dated 22nd May.
Dated?
22nd May 2023.
Yes.
And our supplementary submissions are dated 28th July.
Submissions dated, sorry?
The submissions are dated 22nd.
Supplementary.
The supplementary are dated 28th July 2023.
Yeah.
Then the 27th April application is accompanied by the following supporting affidavits. One by Kauna, K-A-U-N-A.
Supplementary.
Supporting, yes. Supporting affidavit by Kauna, K-A-U-N-A, Ibrahim, Malgui is M-A-L-G-W-I, on 27th April 2023. A supporting affidavit by Juanita Jones. Juanita is J-U-A-N-I-T-A, Juanita Jones, sworn on 27th April. Supplementary affidavit by Kauna Ibrahim, sworn on 10th May. And a further supplementary affidavit sworn by Kauna Ibrahim on 23rd May 2023. The submissions with regard to on 23rd May 2023. The submissions with regard to that application are dated 24th May 2023, and the supplementary submissions are the same supplementary submissions as for the first application dated 28th July 2023. That's what the petitioners have filed. Thank you, my lord.
My lord, on the part of the first and second respondent, with respect to the application dated 11th of April 2023, we filed the replying affidavit of Joanne Redmond, R-E-D, Redmond, M-O-N-D. It's dated the 8th of May 2023. We filed a list of authorities and submissions dated 24th May 2023.
24th
Of May 2023. My lord, this is with respect to both the application dated 11th of April and 27th of April 2023. To file together.
April and 27.
Yes. And with respect to the application of 27th of April, we have filed the replying affidavit of Joanne Redmond, also dated 8th of May 2023. And supplementary submissions and list of authorities dated 16th of June.
Supplementary
Submissions
submission dated
16th of June 2023. Yeah, that's it.
On the part of the third respondent, in response to the application dated 11th April 2023, we filed grounds of opposition dated the 10th of May 2023.
15th April 23, you filed.
Grounds of opposition dated 10th May 2023. And a replying affidavit
Sorry, there, 10.
the 10th of May 2023.
Yeah.
And a replying affidavit dated the 11th of May 2023.
They said.
Keep on.
Yes.
We also filed submissions dated the 24th of May 2023. In relation to the application dated the 27th of April 2023, we filed grounds of opposition dated the 10th of May 2023. And grounds of opposition dated the 10th of May 2023. The affidavit is that of Lillian Kikament.
Can you repeat that? Grounds are dated
10th of May 2023.
of May.
Correct. And the replying affidavit as well. So on the 10th of May 2023. The replying affidavit of Lillian Kikament. We also filed submissions dated the 24th of May 2023. We supplied hard copies, and for your ease of reference, they are green cards for all of our documents.
Yeah.
On the part of the fourth respondent, we filed in response to the application dated the 11th of April, an affidavit by Sven Alphonse de Kauter, dated the 24th.
Affidavit of
Sven Alphonse, S-V-E-N, Alphonse de Kauter, dated the 24th of May 2023. In response to the application
application dated the 27th of April, we have an affidavit by Sven Alphonse de Cauta, dated the 20th.
Affidavit by
Sven.
same person.
Same person. Dated the 24th of May 2023. These were fresh affidavits which we filed, which were admitted into court. We also filed submission dated the 24th of May 2022 on a bundle of authorities of the same date. That's all.
It's on the part of the respondent, the agent. Yes, the 6, 7, 8, and 9. We have not filed any documents because the orders do not directly affect the Attorney General or any of those interested parties. However, we will align ourselves or associate ourselves or support the position taken by all the respondents.
That's it.
Yes, that's it.
All right, my lord. Perhaps you can get direction on time and location.
How long do you want to take? Now
I
it's 11:45.
could you indulge us for 30 minutes because there are 2 applications, yes.
Okay. Answer.
Yeah, about the same time, my lord. Perhaps I just mentioned that even though there are 2 applications, they're actually just one, in the sense of the issue that is being dealt with in the first
I
side.
wanted to start by asking her to explain
Yes.
That's where I
why
begin
there are
also.
2 applications
Yes, that's right.
and not one.
Thank you.
So I will hear from her why
Yes.
there are 2 applications and not one. Yes. So 30 and
20 on my part.
20.
20.
Okay.
And then we can have 10 for rejoinder after. Thank you, my lord. I think you've set the tone of where we begin this highlighting of the submissions, my lord. We need to first explain why there are 2 applications with regards to contempt arising out of the same interim orders. On 21st March 2023, my lord, you graciously granted ex parte interim orders restraining the respondents from proceeding with the redundancy.
Sorry, again, Mama.
So the orders restrained
Sorry,
on 21st March. Yes. So that is the official date of issue of the orders. The ex parte hearing was on 20th March. You issued them officially on 21st March.
Yeah.
Yes, so the orders restrained the respondents from proceeding with the redundancy and also restrained the first and second respondents from giving the work of Facebook content moderation to any workers other than the petitioners. As of the date of filing the first application, 11th April 2023, the contemptuous behavior the respondents had engaged in so that is as at 11th April 2023, the date of the first application, what the respondents had done is, number one, they had sent all the petitioners on compulsory leave, citing that as from 31st March 2023, the date the redundancy was to take effect, the third respondent would not have any content moderation work for them. Number two, the first, second, and third respondents had proceeded to make out redundancy payments
That's a second.
First, second, and third. Despite there being a court order that had stopped the redundancy en masse. Now, soon after we filed that application, there were further developments. To it, the first, second, and third respondents.
I'm writing.
Yes, yes.
So further developments.
Yes, the first, second, and third respondents sent new termination notices to the petitioners stating that their contracts had terminated on the 31st of March by a fraction of time. Then they proceeded to withhold salaries for the month of April, citing that the contract had already terminated at the end of March, and that withholding of salaries,
April, stating
that their contracts had terminated on 31st March. That withholding of salaries has continued to date. And then the petitioners were given 9 days.
and then even 9 days.
Yes, to clear from the company. Which then puts the immigration status at risk. As you are aware, most of the petitioners do not come from Kenya. And that is what prompted the application,
The second application.
yes, dated 27th April 2023, under certificate of urgency, which is what led to Justice Ongaya issuing an order preserving the immigration status in Kenya. So that is the background.
So you're saying this came before Ongaya?
Yes, the application dated 27th April came before Ongaya. Justice Ongaya, he issued ex parte interim orders preserving the immigration status of the petitioners, and later on issued another interim order specifically directed to the third respondent to continue paying salaries to the petitioners. That is the contextual background. So what we have done for the purposes of highlighting is combine the issues, and then as we go, I'll refer you to the relevant paragraphs in each of the submissions. That way we save on time. So despite the separate issues listed in each of the submissions, for the purposes of highlighting, we've combined them into 3 issues. The first issue is whether the 3-part test required to establish contempt of court has been met.
Requires to establish.
Contempt of court has been met.
Yeah.
The second issue is whether the prayers sought in both applications ought to be granted. And the third issue is whether the replying affidavits of the first and second respondents,
Of
the first and second respondents, the replying affidavits of the first and second respondents in response to both applications ought to be struck off the court's record for lacking authentication.
The record for lack of
Authentication.
authentication.
Yes. All right, let's begin with the first test, with the first issue, which is whether the three-part test to establish contempt has been met. And for this, the petitioners associate themselves with the test as articulated by Mwita J. in Sheila Kassat. Kassat is C-A-S-S-A-T versus Anthony Machadha Kinyanjui. You find that on page 46 to 53 of our bundle of authorities dated 22nd May 2023.
Applicant's bundle dated
22nd May 2023. Our submissions also come with bundles of authorities. So this is the three-part test he articulated. The first is that the order must be clear and unambiguous. The second is that the respondents must have had sufficient knowledge of the court orders and the third is that the respondents must have breached the court orders intentionally. We intend to show that all three factors have been established, beginning with the first one, were the orders clear and unambiguous? And for more detailed discussion, my lord, this is addressed in page 25 of our submissions dated 22nd May and page 42 of our submissions dated 24th May. All right? So the beginning point for this is how one is supposed to interpret court orders. And Mativo J, as he then was, in Republic versus Chief Magistrates Court, ex parte Pravin Galot, Pravin P-R-A-V-I-N, Pravin Galot.
These ones are in a list of authorities.
Yes, page 54 to
So
78.
that, it's easier when you say authority one.
Okay. Let me
Two.
let me grab my list of authorities, then I can do that.
It's easier.
Yes. Yes, my lord, that is. All right. So that is authority number 9.
Nine.
Number 9 in the bundle dated 22nd May 2023. So this is the guideline he gives in interpretation of court orders. First is that the court's intention is to be construed from the language of the order and the court's reasoning.
I think I just need to listen to that. Yes, I'll read.
Yes, as read as a whole. That is the most important part. As read as a whole. And second, he says, if on such a reading, it's clear and unambiguous what the meaning of the court was, no extrinsic factor or evidence is admissible to contradict vary, qualify, or supplement it. And even the judge who gave the order cannot be called upon to give a subjective reading of the order. We submit, my Lord, that when you read the orders issued on 21st March as a whole, they were crystal clear that the work of Facebook content moderation was to continue. It was to be done by the petitioners only. It was not to be transferred to any other person, whether directly engaged by the first and second respondents or through any agent. And for that, the petitioners were to stay in employment in order to continue doing the work. Their contracts were not to be terminated by the redundancy or by any reason whatsoever, nor were the terms of their contract to be varied to their disadvantage. And just a note, my Lord, if you read those orders, you went to painful lengths to make sure the orders were as clear as possible, leaving no room for ambiguity. So the first part of the test has been established.
Yeah.
The second part, which is the actual knowledge of the orders, I'd like to refer you to pages 26 to 28 of our submissions dated 22nd May, where we have gone into a detailed discussion on the legal standard of knowledge. But in summary, the test we have associated ourselves to is the test set by the Court of Appeal in Authority Number 10, Shima's Plaza, which is at page 79 to 92 of the bundle dated 22nd May.
29 to
92. And once you apply that test, this is what the test will reveal. Number one, the respondents had actual knowledge of the court order because they were all served, both via email and in person, including serving the first and second respondents via international courier, FedEx, at a great cost, may I add. Number two, they were represented by counsel. Their counsel attended every court appearance. And that specific order was discussed extensively at every court appearance, including by the first and second respondents, who made two separate applications. One before you to set aside that order,
including by
the first and second respondents, who made an application before you to set aside the application for non-disclosure of material facts, and then also applied to the Court of Appeal to stay the execution of that application, of that order. Combined with the fact that the respondents have not contested, they've not disputed having actual knowledge of the order, we have
respondents have not disputed.
Having actual knowledge of the court order, we have established that second test. Which leads us to the third test. Was their disobedience willful disobedience? And my lord, the precedent set in the Shima's case is once you establish that they had actual knowledge, all you need to do is to prove that there was disobedience of the order, and that disobedience will be deemed willful because they had knowledge. So, to fulfill this test, my lord, allow us to review the conduct of the respondents vis-a-vis what the court orders actually required them to do,
Yeah.
and for that we begin with order number C. Order number A and B are not in question in this application. Let's begin with order number C. Order number C, this court provided that the first, second, and third respondents were not to implement anything related to or incidental to the redundancy in any manner. There's a second part where at the end of order number C, the court says, for greater certainty, the first, second, and third respondents were not to terminate the contracts of the Facebook content moderators. Now let us examine the conduct. First thing they did, 28th March 2023, 7 days after you issued the order, my lord, an email was sent to the petitioners we have annexed that email as KMAC 3 attached to the supporting affidavit by Kiana Monique, to the application dated 11th April. And that email, 11th April, that email sent all the petitioners on compulsory leave. What is more interesting about that email is a statement by the sender of the email, Lillian Kiplangad, and I quote, as of 31st March 2023, there will be no work available to summer. There will be no content moderation work available to summer. 31st March 2023. There will be no content moderation work available to summer.
Available to?
Summer, S-A-M-A. That's the third respondent. The second conduct in question is on 27th April 2023. 27th April. There was another set of emails sent to the petitioners. We have annexed this. as KIM 6,
Okay.
KIM, Kim, KIM 6, and KIM 8 to the supporting affidavit sworn by Kauna Ibrahim in support of the 27th April application. And these are a collection of the emails sent to the petitioners informing them that their contracts had expired by a fraction of time. Now, the third respondent has levied over-reliance on this issue of a fraction of time. Which makes it imperative on our part to address the question, does a fraction of time apply in this case? There are three things to note, key things to note on this issue, my lord. The first is that in his ruling on 2nd June 2023, Justice Ogaya has put the issue of expiry of contracts to rest conclusively, where he stated that from a plain reading of the contracts,
Before my learned friend wades into the 2nd of June ruling,
Yes.
the Honourable Mr. Justice Ongaya, in fact, did stay that particular ruling himself. And so it would be wrong.
Sorry.
He
Just
issued-
repeat what you're saying again.
He issued status quo orders
On
regarding the 2nd of June, status quo orders as from the 2nd of June 2023. So it really would be disingenuous.
But we're going to be hearing that from you.
Yes, I'm
To counter
yes,
these arguments.
certainly. I just
Let
thought
us
that
have
I
all
should
the
bring it.
facts on the table.
That's fine. But I just thought I would bring it to
We
your
will
attention.
hear you on that.
Yes.
So let us continue. Yeah.
all right, that's all right, my lord. What the point I'm bringing out here is that the honorable judge said that from a plain reading of the contracts, these were not term contracts. The petitioners were engaged for an indefinite tenure. So already the issue of expiry does
We're
not,
fixed term.
they were not for a fixed term. Therefore, they were for an indefinite period. Now, what is interesting is that despite getting that direction from Justice Ngaya, whether there's status quo orders or not, there's been no effort from the respondents. The most key thing to note on this issue of a fraction of time is that the petitioners had already been issued with termination letters The petitioners had already been issued with termination letters on 8th February 2023.
On 8th of February.
2023. And we have annexed those as KMAC 21. KMAC 21
Yeah.
in the supplementary affidavit sworn by Kiana Monique to the application dated 11th April. So now the legal question before the court is this. The petitioner's contracts having been terminated on account of redundancy via the termination letters of 8th February, could they also be said to have been terminated on a later date by a fraction of time? In short, can a contract of employment be terminated twice for different reasons And we submit that that is an untenable position in law for the following reasons.
You will repeat again what
Okay.
what you told me.
All right.
Just repeat again.
So the legal question before the court.
No, just start again. That argument.
So let me start to where there was there were termination letters, initial termination letters. Do I go up to there? So the point to make there is that the petitioners had already been issued with termination letters on 8th February, yes, 2023.
Yes.
All right? So now that we pose the legal question to the court, which is the petitioner's contracts having been terminated on account of redundancy,
Okay.
can they be terminated later, at a later date, on account of a fraction of time?
Yes.
All right? And our submission is that that position is untenable in law for 3 reasons. The first is that the doctrine of waiver and estoppel requires that the respondents can only exercise one legal route to terminate contracts. And they elected on 8th February to follow the route of redundancy, which means they chose to forgo all other legal avenues for termination and having done so, they are bound by the consequences of that decision. So if the consequences are that the court puts a stop to that redundancy process, the respondents cannot reach back in time and opt to implement a second legal avenue of termination. All right? Secondly, my lord, a contract cannot be terminated twice. We have attached authority number 11, which is a case before the federal court in Australia on page 93 to 156.
Number 11, page
93 to 156 to 156, which explores this issue of terminating through one route and then choosing.
This is a list of authorities.
Yes, list of authorities dated 22nd May. All right? And that case offers clear guidance that if you choose any of the available routes, redundancy, efflaction, or any other termination, you are bound by that route. Because a contract cannot be terminated twice. So then what happens once the court steps in? We look to the authority. Let me just locate it. So we look at the authority at page 50 of the index and bundle. Dated 22nd May, page 50.
Guided by authority number.
So it's a case inside authority number 8. So it's authority number 8, but inside there,
Reference.
it references the Econet wireless case decided by Abraham J, as he then was, where he states that once
Mohammed.
yes,
Ibrahim.
Ibrahim, yes, that once parties now go to court, they submit themselves to a new regime over the contracts, which is you obey what the court says. So you must abide by what the court has mandated until the final determination of the petition. And to just explore the options available in the petition, my lord.
Yeah. Your 30 minutes are gone.
Could you indulge me for a little bit more
Yeah,
time, my lord? I
extra
think,
time. It's 5 minutes. Take note of that.
yes, let me try as fast as I can too. I feel like this was the most contentious
Yeah,
issue
it's okay.
anyway. Yes, all right. So if you explore the two options available to the petition, if, my lord, at the end of the petition you are to find that the redundancy was lawful, then the contract would stand terminated as at the date of the judgment and not a date earlier.
Say that again.
So we are exploring the options available in the petition. At the end of this petition, if this court were to hold that the redundancy was being carried out lawfully,
Yeah.
the contracts would stand terminated as at the date of the judgment, not a date earlier, not 31st March. They would stand terminated as at the date of the judgment. Conversely, if you were to find that the redundancy was being carried out unlawfully,
Yeah.
there are remedies under the Employment Act that would attach. None of those scenarios end with the court committing the petitioners back to their initial expiry periods. And that is what Abraham J said. When you commit yourself to the court process, forget what your contract said, now you obey what the court demands. In any event, my lord, the fact that contracts were terminating on 31st March by a fraction of time is an implementation of the redundancy. Why? Because Annexure KMAC 18 and KMAC 20 and Annexure JJ3, all these are with relation to,
That's the notices. Or
these are Annexure 18 and 20. The 18 is the first redundancy notice.
yeah.
20 is the second one that extended. So specific interest on 20 contains a clause that all contracts and work visas will be extended to terminate on the 31st March. So that then, when the respondents say termination by fraction of time, what they mean is a circumvention of the court orders and that issue of circumvention was explored in Authority Number 14, page 173 to 179, where
That's 73.
to 179 in the bundle dated 22nd May, where the court tells you do not terminate a contract, and then you become creative and look for another legal route to terminate a contract. That is circumvention, and that in itself is contempt of court. So what you will see, my lord, is that the subsequent termination of contracts was an implementation of the redundancy. And number two,
Yeah.
it was a direct violation because your order also said contracts were not to be terminated. For the other orders, is there any way, my lord, I could receive your grace for just 5 more minutes to highlight the other orders? Because they were quite hefty orders. Kindly, my lord. I know you've been extremely gracious. Can I tap into that pot a little bit more?
Yeah, we have equal time.
That's very well.
Let's go up to half past.
Okay.
Because 8 minutes.
8 minutes. All right. So for order number D,
We are on D.
D for dog, that was the order for the contractual terms not to be varied. In a manner that was disadvantageous to the petitioners. And all I will say is that failing to pay salaries is a variation of contractual terms. And we have discussed this in detail.
Variation or it's a negation?
It is actually worse than a variation. It is a negation of the responsibility of an employer. But it is in direct contravention of that court order. And we have discussed that further in detail at page 28 and 29 of the submissions dated 24th May.
Okay.
28 to 29.
29.
Order number E, which is that the first and second respondents were not to engage anyone else to do that work.
Replace. Not replace. The order was saying they should not be replaced.
The order was saying they are restrained from engaging through employment, subcontracting, or any manner whatsoever to contract anyone to do the work that the petitioners were doing. So while the petitioners were on compulsory leave, work was still being done. And the evidence for that is annexed to MM3 and annexed to TK4.
C4.
So
annex.
MM3 annexed to Mustafa Mukhtar's affidavit, MM3, and TK4 annexed to Teslim Tony's affidavit, TK4. Then for order number F, the fourth respondents themselves have admitted in their replying affidavit that they proceeded to hire content moderators, and we produced evidence, KMAC 24, to show indeed recruitment for content moderators by the fourth respondent.
C which annex?
KMAC 24, to show that recruitment was still proceeding after the court order. The fourth respondent said they've been training the content moderators.
You have 4 minutes.
Yes.
Tell me the remedies you're seeking.
Okay. But just to conclude that point so that I don't leave it hanging, they are training,
Yeah.
and we just want to refer you to the affidavit by Kiana Monique that shows that what training actually means is doing the work, because you're getting trained on the platform. You're getting trained as you do the work. Otherwise, the fourth respondent wouldn't be having day and night training shifts.
And remember, you have some minutes for rejoinder.
Yes,
later
yes,
on.
yes.
So,
All right, so
what remedies are you
what remedies we are seeking, my lord?
seeking? Yeah.
That is the second issue. The remedies we seek is first for the CEOs of these companies to be summoned by this court to explain their disobedience. And this order is not sought in a vacuum. The Court of Appeal, in the authority number 10, we earlier cited to you, page 79 to 92, held that it is the managing directors or the CEO of a company that ought to be held in contempt of court where there's been disobedience. We also seek a monetary fine, and we seek guidance from a case you decided in Kisumu, Doris C. Ombara, which is number 16.
16.
Yes, number 16, page 181 to 185, which demonstrates why a monetary fine needs to be levied where there's contempt of court. And just to add, where the contempt is blatant, the awards, the monetary fines should be commensurate. And finally, my lord, having established that the conduct of the respondents was in contempt, the prayers sought in the application dated 27th April also ought to be issued, which are that the second set of termination letters be quashed as they were issued in contempt of court. And also that the petitioners be paid all their salary entitlements. For the third issue, we'll refer you to where we've addressed it in the submissions, my lord, because our time has run out. So pages 19 to 23 of our submissions dated 22nd May.
Yes, I'll take time and go through them.
And then page 14 to 15 of the submissions dated 24th May.
1923 and 14 to 9.
So 1923 of the submissions dated 22nd May, and then 14 to 15 of the submissions dated 24th May. Thank you, my lord.
Thank you. That was 45 minutes.
Okay.
Can you take the same if you wish?
Does that mean I can have 15 minutes?
There are many of you, so
Thank you. Well, please, my lord,
yeah.
first of all, I'd like to invite you to look at our two written submissions for the first and second respondents,
Yeah.
and they're filed on the 24th of May, 2023, and a supplementary supplement set of submissions filed on the 16th of June 2023. I would invite your lordship to look at them because I don't wish to go very much into them in light of the time that we have. I think the principles that apply when considering whether to cite a party for contempt, I think are well set. My learned friend has eloquently put them before you. What she didn't say is that contempt of court are quasi-criminal proceedings in nature. And due to the gravity of the contempt applications, the established burden of proof on an allegation of contempt is higher than simply a balance of probabilities, as in all civil cases. And it's just a little lower than the reasonable doubt. My lord, you see in our submissions we have quoted the case of Mutidika and Bahrain.
You have your list?
Yes, we have the list, my lord. I was trying to avoid having to, it is number, it's number 4.
Number
Yes, in our list of authorities dated the 16th of June 2023, my lord.
Yeah.
That's the principle that's enunciated by the Court of Appeal. And the court has also stated that the onus of proving any allegation of contempt lies squarely on the party who alleges. And it cannot be shifted. And it must be, the proof must be to the standard that the court has already established. And so the main question that confronts you, my lord, is today is whether in the circumstances of this case, the applicants have demonstrated to the required standards, that is the required which is higher than proof of a balance of probabilities and almost, but not exactly, beyond reasonable doubt, whether they've proved that the respondents, and particularly in this case, the first and second respondent, my learned friend has been extravagant in her language in putting everybody in the same basket. I'd like to suggest to the court that the court must look at each and every respondent separately. And secondly, the issue that will confront this court will be whether the terms of the orders, which were itself issued on the 21st of March 2023, were clear and unambiguous and were binding on the respondents, the first and second respondents. And therefore, whether the first and second respondents breached them deliberately. My lord, one only needs to look at the orders themselves to see how impractical it would be for the first and second respondent even to comply, if so to speak. The language of the orders must be considered. And this is not the language of the court. This is the language of the orders as prayed by the party, by the petitioners. I suggest, my lord, that as your lordship will look at the orders themselves, it will be very clear that the orders were overly broad. And they missed the essential detail of making them particular to each individual respondent in their particular capacity in the circumstances of this case. Indeed, I'll show, my lord, that in fact, that broadness was such that even asking for the directors of a company to come before your lordship as a result of those orders is disingenuous. Just look at the application itself and the orders that were sought. In the orders, my lord, in the application, the petitioners seeking yes, this, my lord, is the application dated the 11th of March 2023. And the orders that the applicant was seeking was in substance, I'm looking for the orders of the 2020, sorry. Just let me read them out to you, my lord. Oh, thank you very much. The orders, I'm sorry, I gave myself, thank you. Yes, Lord, the orders that are in contention are the orders of the 21st of March. And 21st of March 2023. And in substance, what the petitioners were asking for in order number 6, C, is that an interim injunction order be granted restraining the first, second, and third respondents from implementing in any manner whatsoever anything incidental to or related to the redundancy notice issued of Facebook Moderators on the 10th of January, as read together with the redundancy notice of the 18th of January 2023. In particular, and for greater certainty, it says, the first, second, and third respondent be restrained from terminating the contracts of the faithful content moderators pending the hearing of this application. It's so broad. Nothing is said about who are the parties of the contracts. Who are the parties in that contract? Who is capable of terminating it? Who is capable of issuing redundancy notices? It's all conflated in this broad statement of the first, second, and third respondents. There is no distinction whatsoever as to who is a party to those contracts. Secondly, in D, is an interim injunction order granted restrain the first, second, and third respondents from varying the contractual terms. Again, it is the supposition here is that everybody, the first, second, third, and even the fourth, have the right or even the responsibility or even the ability or the capability to change the terms of the contract. That is an assumption that is put in the order. In the third one, 8E, an interim injunction hereby granted restrain the first and second respondents from engaging through employment, subcontracting, or any manner whatsoever content moderators to serve the Eastern and Southern African region, through the fourth respondent, or through any other agent, partner, etc. The broadness is such that, my Lord, falls into the kind of difficulties that the courts have noticed. And I've said that the order which is being sought shouldn't be so broad as it catches anybody on earth. Then the F is introduction. The injunction be granted, restraining the first and second respondent from engaging content moderators to serve Eastern and Southern African region on the fourth respondent or through any other agent, partner, representative, etc., and engage through the third respondent. Then there's a prohibitory order being sought. My Lord, the reason I've gone through this is just to show how broad these orders were being sought and were granted at the ex parte stage. and I think it's important to mention this, at the ex parte stage, even as we argue them now, these orders have not been subjected to any argument by the respondent. They've been ex parte orders. And there was a time when the respondent sought an interpretation of those orders. It didn't happen. But what I'm saying basically, my lord, that it's one thing that needs to be taken into account is that an order which is made ex parte must be carefully considered. If the parties on the other side have not had the opportunity to test them and to bring to the court's attention aspects of those orders, which the court probably ought to take into account, then when it comes to any alleged breach of those orders, the court must take into account that they were ex parte orders and take into account the broad language, all-catching statements, which in this case particularly would have no application whatsoever to the first and second respondents. Lordship would realize that when my learned friend was arguing this matter,
the orders have no application to the first and second.
Yes, first and second. Your Lordship will notice that when my learned friend, Ms. Butemi, was arguing this point, she never at any point said that the contracts were not entered into by the first and second respondent. Never did. Yet, she's saying that they should have made changes to those contracts. They should not have made, they should not have issued redundancy notices. She doesn't tell you, my lord, who issued redundancy notices. And what, therefore, what matters which relate to those redundancy notices, whether those matters affect our clients.
You're saying first and second respondent did not issue redundancy notice?
No. And as a matter of fact, as a point of fact, they never issued redundancy notices. They couldn't because they were not parties to the contract of employment. The parties, as your Lordship will hear from my learned colleague, Mr. Omino, the contract of employment between the petitioners with regard to
we did not issue the contracts, so you cannot vary them.
yes, you can't vary them.
And you could not declare the people redundant.
You can't.
That's your.
Yes, we couldn't possibly declare them redundant.
Okay.
As a matter of fact, my lord, as a matter of point of fact, which is not denied by anyone, the first and second defendant never at any time declared anybody redundant. Never at any time entered into a written contract with any of the petitioners. And so they are in a situation where they're being asked to do that which they cannot do, not just as a matter of law, but practically. They can't do it. They're unable to do it. They're disabled to do it. Madam, and one can see this very easily by looking at the affidavits which have been filed in support of the application. Affidavit suggesting, yes, the affidavit, let me just draw attention, I think it was drawn to your attention by Kiana Monique Arenze, and this appears at page 41 of the application dated the 11th of April 2023. And your Lordship will see from, first of all, from paragraph 8 of that affidavit, that what the petitioners now do is provide an interpretation of what they think the orders said. A subjective rendering of what the orders said, not what the orders actually said. Paragraph 8, the petitioner says that my understanding, based on reading of the orders and the explanation of the orders by my advocates on record, are as follows, then sets out what she said it is. That Meta, which is the first and second, and Sama cannot do anything that is or can be construed to be implementation of the redundancy notices. Actually, that's quite true with regard to the first and second. They cannot do anything. They are not able to do anything. It says the redundancy notices issued on the 10th of 2023 and 18th of January 2023. Then it goes on to say our employment contracts with Sama makes it plainly clear that she herself knows that her employment contract will be with Sama cannot and should not be altered in any manner that is unfavorable to us pending the hearing of the application. And then basically, my Lord, just gives your Lordship their interpretation of what the order said. And the question that arises from that, to what extent do these fall within this very well laid out standard and test which has been set out in the law with regard to contempt of court, which is a quasi-criminal proceeding. Your Lordship will look at the submission, but one other thing that would draw attention to, my Lord, is that the applications were supported mainly by two main affidavits, by the 42nd and the 169th, 42nd and 169th petitioner.
Who and who?
One's the 42nd, and the 42nd is it's the one that Malani called it, Teslin Tony Kiewitz.
Yeah,
I apologize for my
actually
terrible.
they are 42nd and 41?
And 169.
169.
Yes. And your Lordship will see that the so-called evidence that they put before you are all suppositions. The evidence of alleged breaches consisting of work done, presumably, in work done in not in conformity with the court order. The first, my Lord, you see it on page. It is it is annexure MM3 by Mustafa Mukhtar, in which he annexes an alleged supposed to have been done during the period during which the order was in subsistence. I'm not only one needs only look at that attachment. The attachment gives no date as to when it was done. The attachment clearly relates to an area which is not even covered by the contracts. The contracts were within Eastern and Southern Africa. This is supposed to be in Nigeria or someplace like that, and Hausa. Completely
in Eastern and
Sorry?
South, the petitioner's contracts
Yeah, the petitioner's contracts.
covered Eastern and Southern Africa.
Eastern and Southern Africa.
Okay.
At least that's what it says, the contracts. This attachment relates to work allegedly done, because we're not quite sure, in Nigeria. No dates, and indeed, my lord, it is not evidence that is provided before you in the way that our Evidence Act requires. There's no certification. The court is supposed to assume that it's all true. The same arises from the next attachment, which your lordship will see attached as TK3. TK3, my lord. And once again, the same situation. No date when this is supposed to be done, no certification as to its authenticity. And this is the evidence which is being put before the court of record. And it's supposed to be electronic evidence. That is taking this court for granted. My lord, there are similar attachments. TK4, again, an alleged communication. There is nothing in that attachment to show who the communicator, who the transmitter, and who the receiver are. You know, these are basic things, but they're so important. And this court cannot be taken for granted and push to the nose of the court anything that's supposed to be evidence. Does this evidence, my lord, meet the test that has been set by the courts? I submit it doesn't even pretend to do so. My lord, and therefore, my lord, just taking into account all that and looking at the evidence that is before you, there is, in my humble submission, no basis whatsoever, not just for ordering the these remedies that are being sought. For instance, my Lord, my learned colleague has said that one of the remedies that is being sought here is that the CEOs of these companies, that is presumably the first and second respondent, be brought before this court. And what evidence is there of these CEOs? My Lord, the evidence that is being put before you is something that's come from the internet that deals with Meta. The first and second respondents are companies, two separate, different companies. One being an Irish company. No one says who the CEO of that company is. What is being put before your Lordship is something out of the internet telling us that Zuckerman is the CEO of Meta. But which Meta? Which Meta company are we talking about here? Are we talking about the first and or the second respondent? Or is it this court supposed to assume that that is so? That clearly takes this court for granted. And sensationalizing everything that has been sensationalized in this court by just putting out names there and saying this court will pull Zuckerberg because he is the CEO of Meta. But which Meta? Is he the CEO of the first defendant or respondent? Is he the CEO of the second respondent? Where's the evidence of that? Lord, I'd like to just in a few minutes let my learned colleague finish up on one or 2 points.
My Lord, I'd only highlight very few issues. My Lord, I think the first thing is to understand the factual context or background in which these applications are being argued. So it's clear that it is the ex parte orders of 21st of March that we are talking about. It is also known that there were subsequent proceedings in this matter, including the 2nd of June ruling by your brother, the Honorable Justice Ongaya. But my Lord, the events that we're talking about can only be from 27th of April and earlier. Your Lordship, when we appeared before you, shortly after the ex parte order was given on the 21st of March, my Lord, it's on record that the respondents asked this court to explain the orders. That is on 28th of March, on the 12th of April, and 13th of April, particularly
And on
13th of April.
not 28,
No, my Lord,
28 March,
28th March, 12th April,
and
and 11th of May. I'm sure my colleague, Mr. Amino, will speak further to that. But in addition, my Lord, the orders, the ruling that was given on the 2nd of June was stayed by your brother. And in addition, my Lord, on the 14th of June, this court issued a status quo ante
on
14th of June, 2023. A status quo ante was issued pending the determination of the first and second respondents' appeal to the Court of Appeal. That appeal is still pending before the Court of Appeal. The status quo order has never been lifted to date. context in which these two applications are before you today. My colleague, Ms. Mutemi, has submitted that there are 3 issues before the court, but I will submit that there are only 2 with respect to the first and second respondent. And the 2 issues are whether the affidavit of Joanne Redmond is competent and properly before this court.
The first one is
Whether the affidavit of Joanne Redmond, she swore both affidavits for the respondent, is competent and properly before this court. And the second issue can only be whether there was willful and deliberate disobedience of the court orders by the first and second respondent. There are no other issues, my lord. My lord, the issue of the affidavit of Joanne Redmond, it is not in dispute that Ireland, where the affidavit was taken and signed, is not a Commonwealth country. It's not disputed. So I agree with my colleague there. However, my lord, the affidavit was taken before a notary public, and it was sealed and signed. The seal is before the court, and the notarial certificate is also before the court. My lord, there was nothing else that was required to be done. In line with Section 88 of the Evidence Act, that affidavit is properly before this court, in your lordship. Your lord, the petitioners have relied on the decision of Pacificio Lucio, that is authority number 1 in our list of authorities of 16th of June 2023. But they fail to recognize that the law with respect to affidavits taken out of the Commonwealth has changed. We relied on Section 88, which allowed affidavits taken before English courts to be compliant with the law in Kenya. My lord, the High Court in the decision of Strabrula, it's authority number 3, my lord, in our list of authorities, very specifically said that the law in England changed. And your lordship, I refer you to paragraph 54 and 55 of that decision at page 27. The law in England has changed. Therefore, appearing before a notary public and having the affidavit sealed, in fact, the court just called it a bonus, but it would be admissible in Kenya. So, your lordship, those affidavits are properly before you. The second issue of whether there was contempt of the orders of 21st of March, without repeating what my senior has very eloquently articulated, your lordship, there was an attempt to lump the respondents together as though the respondents acted jointly. From a reading of the affidavits that are before you, your lordship will note that the petitioners themselves agree that the respondents were acting separately. Your lordship, a contempt application is one that can only be based on facts which are before the court. So the petitioners are required to prove to the standard required in law that there was contempt of court. My lord, if I can start with the affidavit of Kiana Monique Arenze. My lord, I submit that a simple reading of the affidavit will show you that all of the annexures in the affidavit are with respect to items that or issues that occurred between Sama, that is the third respondent, and the petitioners. all of the annexures. There's no single document that is before the court with respect to that affidavit where matter, the first and second respondent, were ever involved. My lord, in addition to that, the affidavit in itself gives an interpretation of the court order. I will not repeat what my senior said, but just to look at paragraph 12 of that affidavit. She's saying that she understands the order to have said X. And it goes on. Though we are not the third respondent, we submit that that cannot be a basis for holding any party in contempt. Your Lordship, I would like to put some context into what my senior submitted on the two affidavits of Mustafa Mukhtar, that's the affidavit of 11th of April 2023, and the affidavit of Jasleen Tony. Your Lordship, it's strike law that parties are bound by the pleadings which they elect to place before the court. My Lord, the application of 11th of April was clear in the allegation that was placed with respect to 11th of April 2023. And I will refer you, Lord, to paragraph 6 at page 28 of that application. The petitioner very specifically said to the court that the first and second respondents have acted in breach of order E and F only. That is what they said.
First and second
Respondent acted in breach of two orders, order E and order F.
E and F.
E and F alone, and no other order. Your Lordship, if you look at the two orders which it is alleged the first and second respondents have breached, they are orders stopping the first respondent from subcontracting this work that the content moderators did to any other party. That is, without reading them, that is what they understood the orders to say. Now, these affidavits of Mustafa Mukhtar and Tony Tesfit attempt to show that content moderation was being done in violation of this order of court. That is the context in which these affidavits are before you. Your Lordship, one needs only to look at the affidavits to see that there is inherent confusion even in the affidavits themselves. For example, Mr. Mustafa alleges and states that he was browsing Facebook in Nigeria, allegedly, and he came upon a post by his friend who appears also to be Nigerian. My Lord, there was no order, very simply, stating that content moderation cannot happen elsewhere in the world. Because, and this is a common fact, Facebook is an international company. Content moderation is ongoing even as we speak in other parts of the world. It's sufficient for him to say that because he came upon a post in Nigeria, then there was content moderation. It's conjecture at best. So apart from the fact that even the annexure itself is not dated, doesn't really show any relationship between the court order and the application before you, it's wholly irrelevant. And my Lord, the same would apply to the affidavit of Jasleen, it's an extra TK3. Your Lordship, in fact, that annexure TK3 is even dated March 17th. If we can assume that it is March 17th this year, that was before the court order was given. The court order was given on 21st of March. So it appears clear that the petitioners were simply fishing.
So those relate to which date?
March 17th is when the alleged post was made. The order by the court was issued on 21st of March. If we can assume that it is 2023.
Okay.
Yes, my lord. And then the report, which is the next one, TK4.
Are you about to stop now?
Yes,
2 minutes.
Yes, I am, my lord. 2 minutes and I will stop.
45 minutes.
Okay. My lord, the next annexure, which is TK4. TK4 is the annexure that of an alleged report. We can't reconcile the two documents. My lord. It's not. We cannot say that the report relates to the alleged post. That's the point I wanted to make there.
You cannot relate which report?
So, my lord, the context in which she's sworn her affidavit is that
Tesla.
Yeah, Tesla.
Yeah.
On the Facebook app, if you find an offending post, you would make a report to Facebook and say that the post violates Facebook's community standards, and then you would get a response. Yeah? So, Your Lordship, if you look at the way the affidavit has been placed, she puts a post which was made prior to the court order being issued. Then she puts another response, which is dated 6th of April 2023. So one wonders, what was happening? Was she waiting for the court order to be given, and then she makes a report? It's questionable evidence at best.
Okay.
My lord, with respect to the second application, my lord, the same thing can be said as I wind up. The affidavits that have been annexed in support of that application, my lord, and I will start with the affidavit of, again, Juanita Jones, who is the 40th petitioner. Without saying much about that affidavit, all of the annexures and all of the issues with respect to that affidavit are things that happened in Kenya and between the petitioners and the Juanita, I'm not sure if I'm getting that right, but Juanita.
Relates to?
Issues that happened in Kenya and with respect to Sama Source, the third respondent.
Respect to third respondent, not first and second.
Not first and second. And it admittedly so, when you look at the affidavit and look at the annexures, nothing about mental there. And my lord, the same thing with respect to the affidavit of Kauna Malwi. I believe she's the She's the 15th petitioner who also saw an affidavit with respect to the application of 27th of April. Nothing there. But a very humble submission is that the petitioner's application has fallen far short from the requirement, the standard of proof with respect to court applications. My lord, the last issue is that the certificates of authenticity that have been placed before you, all of them, they fall short of the mandatory requirements under Section 60 and Section 104 of the Evidence Act.
Under Section 60
and Section 104 of the Evidence Act. What is required of a fact?
Electronic evidence?
Yes, electronic evidence. Yes, If I can just explain this point before I sit down.
Yeah, you are
Yes, my lord.
past your time.
Yes, just the last issue.
You are supposed to supplement senior.
My lord, the last issue, my lord, I'm just looking for the evidence act. Documents disappear when we need them the most. The Evidence Act states that with respect to digital evidence, a party is required to give particulars my lord, because it relates to all the affidavits, I will not go through all of them. But what the petitioners are doing is that they are downloading items from their phones, and they say, I downloaded on my iPhone 7, for example, and forwarded to the petitioner's counsel. In this case, Joyce Gazzoni, who also saw an affidavit. My lord, Section 60 of the Evidence Act states that you must give particulars of the electronic device that you used to share this document.
Saying particular the device is not given.
Yes, my lord. And it's not, it might seem petty, but it is not, because digital evidence is very highly able to be compromised. And these are petitioners who have an interest in this matter. Without accusing them of anything, the court needs to be satisfied that they have met the very stringent conditions under the Evidence Act. If not, those affidavits have to be rejected. That is all.
Okay. Getting tired, Mr. Omino.
Proceed?
Huh?
May I proceed?
Yeah. Proceed, yeah.
Lord, I will go right into it and begin with a preliminary point relating to the two reply affidavits that we have filed. Lord, I will concede that when these two affidavits, when one particular affidavit was originally done, and that would be the affidavit of Legal in response to the application of 27th of April.
Yeah.
It was commissioned before an advocate who had not taken out a PC for this particular year. When we picked up the matter, my lord, we filed a complying. We ensured that a fresh affidavit was commissioned before an advocate licensed to practice for the year. And counsel concedes that report. Her only gripe with our action is that we should not have replaced that affidavit. My lord, that issue had been dealt with by your brother in relation to another affidavit in his ruling of the 2nd of June. And in that ruling he said, I see no issue at all. That affidavit was filed within time, as ordered by the court on the 27th of April, and that the petitioners have had an opportunity to file a further reply to those affidavits. And so absolutely no prejudice would be suffered by the petitioners. In fact, I go on to point out in the Lord that the petitioners themselves did not comply with the order of the court on the 27th of April. And it's for that reason that we were unable to argue these contempt applications before your brother on the 25th of May. And it is why he deferred the hearing of these two applications, and we only had the application for injunction. And so I'm just saying that what is good for the goose must be good for the gander. They got the leeway because there was no danger to us, and the same applies in relation to affidavits. And that would be those affidavits. Moving on, I will begin with the application of the 27th of April 2023, because it is perhaps the most contentious one. And it relates purely to the question, once the dates of expiry of each individual contract arrived, should the third respondent have continued to pay salaries? Now, my lord, before I go into how we read and understood the order, and when I say we, I mean the third respondent, I will begin by pointing out, my lord, to how the petitioners themselves read and understood the order. Note in the affidavit of Kiana Monique, sworn on the 11th of April 2023, in support of her application of the 11th of April, at paragraph 12, she says this about her understanding of your order of the 21st of March. And I quote, "This means that for those of us, such as myself, whose employment contract had not expired, we ought to have remained in employment, going to the office at our normal hours and working." That affidavit, my Lord, has been sworn not only on her own behalf, but on behalf of all the other petitioners. On that admission alone, my Lord, the petitioner's advocate should not be allowed to urge evidence, to urge arguments, however innovative. And I must say the arguments are extremely innovative. But they cannot be allowed to urge any evidence, that is, any submissions contrary to the evidence on the record. And my Lord, it is always said that submissions are merely marketing language. They cannot be accepted as any evidence. The only evidence we have is that of Kiana Monique on behalf of the petitioner saying that anyone whose contract has expired should not remain in employment. And she has spoken for all the petitioners. Lord, we have referred to an authority, Synergy Industrial Credit Limited, which is our authority number 6, where the court said, a clear and my Lord will read it at paragraph 25 of our submissions, where the court essentially says, paragraph 25 of our submissions, where the court says a clear and unequivocal admission of fact is conclusive, rendering it unnecessary for one party in whomsoever the admission was made to adduce evidence to prove the admitted fact, and incompetent for the other party making the admission to adduce evidence to contradict it. So therefore, my Lord, based on that admission by Kiana Monique, the court should not accept any evidence to contradict what they understood that order to mean.
That was her interpretation.
Their interpretation, but you see, my Lord,
The whole.
indeed. And it goes to the question of contempt, because they cannot arrest that we in contempt when they understood the order the exact same way that we understood it. So then they fall far short of the standard of proof, which is above balance of probability, but just below reasonable doubt. My Lord, then I will then move to the innovative argument I've referred to, that the Petitioners' Council has introduced.
They understood the order not to stop expiry of contracts by a fraction
By a
of time.
fraction of time, correct. The innovative argument, my Lord, that has been introduced by counsel is that there can be no termination twice. And she has referred us to a very interesting authority by the Federal Court of Australia, and specifically, my Lord, to a specific paragraph, I will find it. Paragraph 112. That would be authority number 11 of the petitioners.
By 11.
Yes, authority number 11 of the petitioners. That would be at page 128 of the bundle of authorities.
That's the Australian case.
Correct. And Lord, in that authority, the Federal Court of Australia says a contract cannot be terminated twice. And that's fair. But my Lord, if you continue to read this authority, it actually supports our position. Because while the court says that a contract cannot be terminated twice, the court went on to determine in that case whether that contract was already deemed to have been terminated by way of redundancy. And my Lord will read paragraph 122 of that decision.
Position at
Paragraph 122.
of the judgment.
Yes. will not read it, but I will read it fairly quickly. It says, the letter of 3rd June 2013 advised Mr. Sotner that his position as Director of Commercial Business would be redundant as from the 3rd of June 2013, and that he would be entitled to 6 months' pay in lieu of notice. It goes on to say that it also offered certain redundancy payments. However, my lord, for context of this case, once the notice was issued, the employer realized that this individual had been undertaking some nefarious business in the course of his employment. They then withdrew their notice and said, no, we are terminating you for cause. At paragraph 123, so the court said, was the employer right in doing so? Had the redundancy termination taken effect? And the court said it had not. At 123, it says, in order for it to have been effective, it was merely a notice, but in order for it to have been effective, then the payment of the dues and the notice had to have been made. And the court in that said this never occurred, and there was therefore no termination on account of redundancy. And so the court upheld, in fact, this was an appeal by the employer. The court said the employer was absolutely right, because even though you cannot terminate twice, there was no termination. Because the termination date had not yet come, the redundancy dues had not yet been paid, and there was therefore no termination at all. You will see, my lord, again at paragraph 132 and 133 of that decision, where the court says exactly what I'm telling you. It says, accordingly, at the time that Mr. Stockner's misconduct was discovered, his employment contract was still on foot. And so the employer was meeting him on account of your conduct. That authority, my lord, at page 104, goes on to quote other authorities which support that position. And so, my lord, their own authority supports our position that even though a redundancy notice has been issued, that redundancy would only have taken effect on the 31st of March and not a day earlier. On the 21st of March, the Lordship gave an order stopping the redundancy process. So the redundancy process was stopped. The question then becomes, my lord, was expiry of contracts also stopped? The court only stopped the redundancy process. The question becomes whether the expiry of contracts was also stopped by the court. Now, counsel for the petitioner argues that the expiry of the contracts was so intertwined with the redundancy that you cannot separate. But from their own pleading, that is not the case, man.
But they on fixed term contracts?
They were on fixed term contracts. They were on fixed term contracts. My lord, if you look at prayer G of the application of 17th March, one of the ex parte orders that had been sought at prayer G read as follows: that pending the hearing and determination of this application, this honorable court to be pleased to issue an interim order that any contracts that were to lapse before the determination of this petition be extended, such that the termination date will be after the determination of the petition. So if they really thought that these two things were so intertwined, why did they seek a specific order for extension of the expiring contracts? I go on to say, my lord, that you consider that prayer at the ex parte stage, when the file was brought to you in chambers. It was a prayer among other prayers. The Lordship then proceeded to grant the prayers that you thought were merited. And we have no quarrels with that. But your Lordship proceeded to grant orders that you considered merited. But you did not consider prayer G to be merited. And you did not grant it.
Prayer G?
Yes, prayer G of the notice of motion application dated the 17th of March, which then led to the ex parte orders of the 21st of March.
Dated?
Dated the 17th of March, 2023. It is those orders, it is that application that led to the ex parte orders of the 21st of March. And so, my lord, sitting back at the ranch as the third respondent, and looking at the prayers sought, and looking at the prayers that were issued by the court, is it reasonable, my lord, for the third respondent to have said, if the court really did intend for these contracts not to expire, nothing would have been easier than for the court to say, I grant pledge. And so it was a reasonable reading of your order, my lord, that the contracts would continue to expire. Because then otherwise your lordship would have granted the order. My lord, to show our good faith, and because one of the things we have to show that was a willful disregard of the orders of the court. When we appeared before you, my lord, and I'm glad that the proceedings have been timed. On the 12th of April 2013, 2022, when we appeared before you, my lord, you will see that I raised the issue at page 19 of the typed proceedings. You will see, my lord, I said, I wish to address you on the issue, on one issue, in the interest of justice, so that applications for contempt are not brought. And I went on to say, my lord, how do we deal with employees whose contracts have expired by fraction of time? That was my question to the court. On that day, the court said, I will give you my directions the next day. It was supposed to come before you on the 13th. My lord, we came back before you on the 13th of April for highlighting of submission of the question of jurisdiction. And at the end of that highlighting, I rose again. And I told your lordship, as this had been raised yesterday, the issue was on clarification on the part of any contracts that had expired. And this was in the interest of everyone being aware so that no one brings a contempt application. Your lordship on that day indicated, look, you do not want to go into what you had ordered or what you hadn't, but you off the cuff said that everyone knows what the effect of a fraction of time is. It may not be on the record, my lord, but that was your off the record comment. Armed with that, my lord, and doing the best we could do, we went back to the law and then looked and said, because in defense of the petitions, there was an order saying, do not terminate this contract. So we went back to the law and said, there's an order saying, do not terminate the contract, but there's also an order, the court declining to grant an order to extend any expiring contract. So we went back to the law and asked ourselves, is expiry of a contract by a fraction of time, does it amount to a termination of the employment contract by the employer? And we obtained authorities, my lord, including authority number 1 on our list, Raja, Baraza, and 4 others. That's
Authority
number 1 on our list. Raja, Baraza, and 4 others. Versus KMC. And this would be the decision of your sister, Justice Mbaru, where she says, the law is that the expiry of fixed-term contract of employment does not constitute termination of the contract by any of the parties. There is an automatic termination of the contract by operation of law, and it is not a dismissal or unfair termination of employment. Lord, we have also indicated to you at paragraph 12 of our submissions, which is authority number 2, a decision of the Court of Appeal. A decision of the Court of Appeal, my lord, being Emmanuel Mutembe Ntambi.
Appeal decision, which is authority
number 2. And it is quoted at paragraph 12 of our submissions.
Yeah, on the same point.
Correct. So the court essentially said termination of the appellant, unfair or otherwise, was not an issue because the contract expired by a fraction of time. So a question of termination cannot arise. But more to the point, my lord, would be the Court of Appeal decision in Trocare, T-R-O-C-A-I-R-E, T-R-O-C-A-I-R-E, versus Catherine Wambui Karuru. It is the third authority on our list, and it is quoted at paragraph 30 of our submissions. My lord, in that case, the employer had in fact even issued not only a redundancy notice to the Ministry of Labour, but had even paid what they termed as redundancy dues. When the employee went to court, even though the employment court found in his favor, when he went to the Court of Appeal, the Court of Appeals said, that being the case, the reason given by the appellant in his letter to the Ministry of Labour for his decision not to renew the respondent's contract and the payment of what was termed as a redundancy package in our view has no relevance in this dispute. We also find that the same could not have been a basis of finding that the respondent had been declared redundant. The court went on to say, once a fixed term contract is at an end, the employer has no just obligation to justify termination on other grounds beyond the lapse of the fixed period. And that decision of the Court of Appeal, my lord, is on all fours with this situation. Where again we're saying, yes, redundancy notices were issued, and the redundancy process was stopped. But that cannot stop a contract from expiring by fraction of time. There is a further decision there by your brother, Honorable Ngaya, we quoted page 14, and that will be authority number 4 on the same court. And a further one we quoted again in James Magondo, which is.
Do I understand you the facts
Yes.
to be that contracts expired by a fraction of time
Yes.
in respect of all the petitioners, or do we have those that did not expire by
Yes, understand. We
fraction of time?
We have two. We have two who had open-ended contracts, and we continue to pay them today. And even for the ones, and your lordship would perhaps look at the affidavit.
Well, I haven't read.
Yes, oh yes, absolutely. Your
I
lordship
looked
would.
at the facts here.
We have annexed to the affidavit of David and Kipling a schedule.
So you only two.
Only two we continue to pay. And we, if you look at the affidavit of David and Kipling, not all the petitioners' contracts were expiring on the 31st of March. There were some who were expiring in April, some in May, and some in June. The last term contract expired on the 14th of August. And we continued faithfully to pay. For anyone whose contract was still alive, we continued
to
faithfully.
pay, or they continue to work.
My lord, and I will come to that in the application of the letter, and I will come to explain it. Right? But for them, we continue to pay faithfully.
Yeah.
And so, my lord, in closing, on the question of contempt in regards to the fraction of time issue, my lord, you will see that those contracts by law efflux by fraction of time. But even in the rare occasion, my lord, that you will disagree with us on that point, after the authorities have shared with you, even if your lordship will disagree with our interpretation of that court order, our decision cannot amount to contempt of time, because we made a judicious interpretation supported by authorities up to the Court of Appeal on the point. It wasn't one that was made in a hurry or to circumvent anything. As a matter of fact, we even came to your lordship to be cocksure on what our interpretation was. And so even if in the end your lordship finds it reasonable to disagree with us, and we submit that you, on the facts here, my lord, I think we are right. But even if your lordship was to disagree, it cannot arise to contempt. It cannot arise to contempt. We did the best with what we had, and here we are. I will very briefly also submit on the application of the 11th. And on that application, my lord,
11
of April 2020. And my lord, the first allegation of contempt in that application against the third respondent was the action of sending the employees on admin leave. It is agreed that on the 28th of March,
employees on compulsory leave.
yes, it was referred to as admin leave. For why that reason?
This was done
On the 28th.
of
On the 28th of April, of March, sorry, of March. Before the contracts even expired. Everyone was still an employee at that stage. Now, my lord, the reason, number one, that was done, and why we say it is not in breach of any court order, is that the only order that was given was one, stopping the redundancy process. There was no mandatory injunction, my lord, that said they must keep showing up at the office. Oh, there isn't. And to make that allegation, we have to stretch the truth a little too far. And my lord, in our submissions, we have indicated an authority which distinguishes between a mandatory and a prohibitory injunction. Similarly, my lord, if you look at clause 4.3 of the employment contracts, which is annexed to the supporting affidavit of KNME, it says that shift allocation will be at the discretion of the employer. So the employer is entitled to tell you, do not come on this day or do not come on that day.
Just to repeat that again,
Clause 4.3.
Clause
4.3 of the employment contract, the petitioners, provided that shift allocation would be at the sole discretion of the employer. And your lordship would recall that there was another order saying that the contract should not be valid. And so therefore, if the employer tells you at their discretion, do not come for the shift, they're not in breach of the court order. In fact, they're complying with the court order because the court order said, do not vary the terms of the contract. But even more importantly, my lord, if as an employer you are served with a petition in which your own employees say, this work is so toxic that we are suffering from a very serious mental illness called PTSD, Lord, it would be the height of recklessness. The height of recklessness to demand, after being informed of such a thing, because we say it was the first time they were being told by any employee that they are suffering PTSD, to demand them to be at their desk and continue doing that same job which they have come to court and say is so toxic that they are suffering from a serious mental condition. Doing the best with that information, my lord, they were sent on admin leave. Further, and still very importantly, my lord, it is part of the proceedings, admitted by all parties, that the third respondent was providing a content moderation service.
Just a minute. Yeah, what was that again?
It is a conceded fact by all parties in this proceedings that the third respondent was providing an outsourced content moderation service to the first and second respondents. It is also admitted by all parties here, including the petitioners in their own petition.
Right, outsourced.
Yes. It is also a conceded fact by the petitioners in their own petition that that contract had come to an end and that the contract had been awarded to a new service provider, who is the fourth respondent. And in fact, in the email of the 28th of March, the third respondent says as much. He says, look, this is the best we can do because we no longer have the contract. We have no work to give you of content moderation. Because as you are well aware, the contract has been given to a fourth respondent. So doing the best with what they could, my lord, they have no contract, but they are ordered to stay with them. They said, we'll stay with you until the end of the contract, but we have no work to give. So this was a genuine decision on the part of some.
Stayed with the two.
No, on the 28th of March, everyone was still in employment.
Yeah.
Everyone was still in employment. The ones who contract expired on the 31st of March were paid on the 31st of March. Anyone whose contract expired in May, and there's many of them, were paid until the end of May. Anyone whose contract went on until August,
Paid with all of them up to 31st.
up to their individual dates of expiry of the contracts.
Yeah.
The individual dates of the expiry of the contracts. There's a schedule for when each individual contract was expired, which is provided. So if your contract expired in August, we continue to pay with no qualms. That is how seriously we took that order. Like I said, my lord, because there was no outsourcing contract matter anymore, there was no work to give these individuals. So the third respondent did the best that he could in the circumstances. My lord, the second allegation of contempt in the application of the 11th of April is that the third respondent in that same email of the 28th offered an olive branch to the petitioners or to the employees and said, please guys, we really would like to settle this matter with you. These are the terms we propose. These are the terms we propose. And at that point, my lord, I must point out there were only 47 petitioners at the time. Out of more than 200 employees at that time, on the 28th of March, there were only 47 petitioners. But the third respondent wrote
You said there were
47 petitioners at the time.
Up to what time?
This is the 28th of March. The other petitioners only came in, I think, sometime in April. So at that stage, as the employer and as a party to the dispute, someone wrote to all its employees and said, we are aware this case exists, but if anyone would like an amicable settlement, we are providing an offer for settlement. And some terms were provided, and a draft settlement agreement was provided. Now, at the bottom of that email, my lord, the third respondent was very careful to say, in the interest of transparency, we are copying in the lawyer who's the petitioner, who's the lawyer for the 47 petitioners, to this email, in the interest of transparency. And she was and Ms. Mutemi was copied in on that email. Father, my lord, and the email and the draft settlement agreement have been annexed to the supporting affidavit of the petitioners, that application. If you look at this proposed settlement agreement that was offered, there's a clause which specifically and explicitly states that you will only sign this agreement after you have taken separate legal advice, either from the petitioner's advocate or from any other lawyer of your choice. Now, my lord, we have now been accused of contempt on that basis. I must begin by hastily pointing out, my lord, that for contempt to exist, you must point out which order has been breached. My lord, there was no order preventing a discussion between the employees and the employer on a potential settlement. In fact, my lord, on more than 2 occasions, you yourself and your brother, Mr. Songaya, have urged the parties to pursue a settlement. And so, to be cited for contempt for doing exactly that, my lord, I think is a little unfair. And there's authorities which indicate, my lord, and we cited them in the submission that you've got to read, that conciliation is the bedrock of industrial peace. It is the bedrock on which industrial relations are formed. And so to outlaw it, to essentially criminalize a conciliation process, would be to go against the very spirit of this court and of Article 159 of the Constitution. Further, my lord, Rule 19.1 of the rules of this court indicate that the court has the power, and the court shall, in circumstances, order conciliation, negotiation, etc. That is the spirit upon which this court was set. And so, for anyone to be victimized for attempting to enter into settlements in Europe would be unfair. Now, my lord, I have to disclose, my lord, that discussions between the parties should be allowed to go on. And since then, more than 50 of the petitioners have themselves come and said, I want to settle. In all those situations, my lord, we have told them, write to your advocate and send us proof that you've written to her or that you've taken advice from her, and that's settlement agreement before you sign. They have not signed a single mutual separation agreement without that requirement. And my lord, we will be filing an application with those particular employees be removed from this proceeding. Including, in fact, my lord, as recently as after the mediation fell apart. there has been up to 5 employees who come forward and said, because I do not have complete visibility on what was offered at the mediation, I want to settle directly. Even for those 5 employees, we have said, send to us proof that you have informed your lawyer of your intention to settle, and that you have taken separate legal advice, and we will sign the separation. And so, my lord, an offer of settlement in good faith, because none of the employees are forced to take it. And that is why we say they must inform their lawyer, or we will inform their lawyer on their case. It is offered in good faith. And I think the third allegation of undue pressure is similarly the same. It is so false on that. So I submit, my lord, that we are not in contempt. We have done the best that we could to not only try and settle this claim with employees who we cherish as an organization, but we have also tried to comply with the court order in the best manner that we could, and understanding it as genuinely as we could. Even if your lordship again found that we were wrong on response, you will see that we did it genuinely and based on veritable legal grounds. And so, your lordship may find us wrong, which is of course preventable. But I pray that if that is the case, my lord, then it cannot rise to the level of contempt. And we have shared the Supreme Court authority on the point that even though the court may disagree, if the alleged contender has did what they did, doing the best they could, then it does not arise to the level of contempt.
Okay, we have the last person now, is it?
Yes, madam.
I hope you will not be long yourself.
No, I
Are
don't
you,
intend.
are you related in this in any way to this matter? This is the fourth respondent.
The fourth respondent, and you're not related at all to the third respondent or to the first and second. I'll try to be brief, but the first I want to deal
That
with
is Mr.
Batia.
Bhatia.
I'd just like to address one point in the submission, which Ms. Mutemi may not have clearly alluded to. One of the issues related to the affidavit sworn by the fourth respondents in response to the application. That point has since been dealt with because our client has put in fresh submission, which now addressed the issue potential there, which was the practicing status of the advocate who commissioned those documents. The fresh compliance affidavits were filed and were admitted to the court record. So we shall rely on these affidavits, all dated the 24th of May.
Affidavits
Dated the 24th of May.
24th of
May 2022.
the phone to bar, the post to bar.
Sven Alphonse.
Also,
Yes, yes. Turning to the issue of contempt, the allegations of the alleged conduct by the fourth respondent that is alleged to be contemptuous is contained in ground 8 of the notice of motion dated 11th April. In there, the petitioners state that the fourth respondent has acted in breach of Court Order F by proceeding to engage Facebook content moderators.
Order F.
Yes. Who are currently being trained on how to conduct Facebook content moderation. The conduct that is alleged to constitute contempt involves the fourth respondent engaging Facebook content moderators. First of all, we'd like to let the court look at Order F. Order F states that an interim
injunction order, here is hereby granted restraining the first and second respondents from engaging content moderators to serve and to do the work currently being done by the moderators engaged to the third respondent. Order F is clearly and ambiguously an injunction against the first and second respondent, and not the fourth respondent. Therefore, the fourth respondent cannot be held to be in contempt of an order that is not directly binding on it. That an order has to be binding on an alleged contemner was dealt with in authority number 2, Samuel Mweru versus the National Land Commission. Where
So who is the fourth respondent? Who do you work for?
the fourth respondent is a Major Kenya Limited, a BPO service provider. It's independent of the third respondent, Samasos. Majorel, in a similar way to the third respondent, lobbies for outsourced work, including content moderation.
Outsourced work.
Yes.
So who is your principal?
It has customers, the fourth respondent has customers, such as the first and second respondent. Yes, but it provides outsourced services to customers like the fourth.
So the
first and
allegation
second.
in this matter is it that you are working on behalf of the first and second respondent in whatever you've been alleged to have done?
We are alleged to be conducting.
Is that what they say? I will have time to go through it. Is that what is being said? That whatever you are accused of, you're doing on behalf of the first and second respondent?
We're not being accused of doing it on behalf of the first and second, but we're being accused of engaging Facebook content moderators and training them on how to conduct Facebook content moderation.
For yourself?
For ourselves. So as an outsourced service provider, the fourth respondent hires its own staff and who it allocates to conducting the work of different customers, including the first and second.
So you are referring to some authority?
Yes, I was referring to authority number 2.
You have your list?
Yes, I do. So authority number 2.
The list dated?
The list dated 24th of May. I'm sorry, the authority number 3.
Number 3.
Where Machivo J stated that the terms of the order need to be clear and unambiguous, and it must be binding on the alleged contemner. We submit that order F and also order E are not binding on the fourth respondent.
In order E and F
Yes.
are not binding
On the fourth respondent,
on the fourth.
as they're binding on the first and second. But in any event, my lord,
So this case did not affect your work at all?
it affected the work quite greatly. In fact, as a consequence of the orders, our client has been unable to conduct the content moderation work which it was expected to conduct. And for 7 months, that situation has obtained. Very recently, the fourth respondent has been forced to consider redundancies in relation to the 215 staff which was currently employed. And
So you're saying you have 215 staff?
yes, who were employed prior to the institution of the suit. And we have addressed that. And I sent you in the affidavit.
That is in your papers.
Yes.
These were employed before.
Before. And in fact, if you look at paragraph 41 of our submission, I will refer you to paragraphs 8 to 12 of the fourth respondent's replying affidavit. We gave the background, the factual background as to what happened. The fourth respondent expected to conduct the work on, to commence the contempt work on the 1st of April. In order to be able to commence that work on the 1st of April, they already had 230 at that time content moderators, and did so at its own cost and risk. These moderators came from various parts of the African continent, and we say there in 41D that a recruitment exercise of that magnitude and complexity could not have been completed in a matter of days. The court will note that the suit was filed on the 17th of March 2023, and the order served upon us on the 22nd of March 2023. This was 10 days to the commencement date of the project commencement date of 1st April.
The commencement date of
1st April
April.
2023.
So the new employees were supposed to start working from that day.
Yes, on the 1st, and to go live with the work. And we are saying very clearly that they have been employed prior to that go live date. Yes. Now, there's a question of whether or not the fourth respondent could have recruited staff during the pendency of the order, and we direct the court to order G. And it contains a prohibitory order which restrains the first, second, and fourth respondents from refusing to recruit qualified content moderators
In jumps, first, second, and
and
fourth.
fourth. And this is key, from refusing to recruit qualified content moderators on grounds that they were previously engaged through the third respondent, pending the hearing and determination of the application. The court will note that order G does not restrain recruitment, but it directs the manner in which the recruitment should be done.
So you are restrained from
Refusing to
refuse.
recruit, but we can recruit. But in any event, the recruitment was done prior to even the execution of the suit. In support of the contentions, the petitioners had annexed some job postings in KMA 7. And the court will note that those job postings all expired in July 2022, well before when the suit was instituted. But those were submitted in evidence of the alleged contemptuous conduct of the fourth respondent. We to submit that those are irrelevant and cannot be provided in evidence for those allegations. But that they also provided KMA C. '24, the training being conducted by the fourth respondent of its staff is contemptuous. It's freely admitted in the affidavit that following the issuance of the orders, that the fourth respondent did not proceed to do the content moderation work, but having brought in and chipped in all this stuff, and in fact, for the non-citizen, non-resident staff, which had been providing even accommodation, etc. for them, what it did was, it continued to train them and onboard them into the company, and to train them on anticipating that eventually the orders will be lifted, and that is really important. But the petitioners are trying to make heavy weather of that admission to try and allege that the training involved actual moderation. The court will see in paragraph 49 of our submission and in our authority number 4, an excerpt of the Cambridge English Dictionary and the definition of training. Training simply means to prepare someone for a job, activity, but does not involve the doing of the actual work.
So you're saying the staff you recruited, you are continuing to train them?
We had been doing that for 7 months, and onboarding them and trying to use them productively, but they're not done anymore as a consequence of the order. But the first petitioner in the affidavit tries to allege that the fact that some content moderation was being done is proof that that moderation is being done at the fourth respondent. And we address you on that point in our submissions from paragraph 60. The court should note that further moderation, first of all, is not only provided by either the third respondent, the fourth respondent, the petitioners for that matter, but it's a service that is provided across the world. It can be done by persons other than the fourth respondent, and that's what we contend. The first petition also tries to raise the issue of the training that she received while at the third respondent, which involved actual moderation, as evidence of the training that was being conducted at the fourth respondent. So the court will recall that the third and fourth respondents are competitors in the market, are totally unrelated, and they do not coordinate or share on any matter related to training or other operational processes. So the experience that the first petitioner received at summer is not evidence of what is being carried out at majority of the fourth respondent. We are also quite concerned and I believe that with the standard of evidence which has been provided, and that latter point related to that. And then finally try to address you on one point about the summonses which are being sought to be issued as against the fourth respondent, board member Mr. Thomas McIntyre. The first petitioner produced a document, KMAC 25, to support a contention that Mr. Thomas McIntyre is a board member of Majorel Kenya Limited.
Thomas
McIntyre. M-A-C-K-E-N-B-R-O-C-K.
K-E-N?
K-E-N-B-R-O-C-K.
So allegation is a board member
of that relates to Majorel Group Luxembourg, S.A. That's a corporate entity that is separate from the fourth respondent, Majorel Kenya Limited. Majorel Group Luxembourg, S.A. is not a party to the suit. Mr. Thomas McIntyre is not a party to the suit. We refer you to the authority
5, which provides in summary,
Provision number 5.
that's Geoffrey Katuri, which provides in summary that the corporate veil must be lifted in order for summonses to be issued. It's against an individual in the company. But to be clear, Mr. Thomas Mackenwood is not a director of Nigeria Kenya Limited, and we address that point further in our affidavit.
Yes.
As a final point, I want to just reiterate the fact that the fourth respondent has been observing the orders, whether or not they apply, has observed even the spirit of those orders. Having already hired staff, it did not want to immediately declare redundancy, and it has continued to honor its commitments to the staff that it has recruited. We had actually put an affidavit before where we stated the amount that was expended in detaining those staff members, which was about 50 million per month. And the investment in the attempt to try and be ready to take up the contempt moderation project, that prior investment was about 200 million shillings. But in any event, the fourth respondent has complied, and unfortunately finds itself in the position where it has to try and resign its business and is considering redundancy. That's all I wish to say.
Thank you.
My lord, just 1 minute. I know you had said you aligned with the respondent.
Yes.
But
AG.
yes,
Yes.
the most important thing that the court should take from these proceedings is the huge public interest that is in the matter.
Lord, may I object on a point of law? If counsel for the AG did not file any proceedings, it becomes a bit difficult. And this is a trial by ambush, because then we don't know what their position is up until this very minute. And I think that goes against the principles of a fair hearing.
Marcy saying.
My lord,
Just a minute. She's objecting to the AG making submissions.
Yes, my lord, I'm objecting to that because they didn't file anything.
They did not file anything.
In fact, they're on record severally saying they're not going to participate in this application, only to ambush us at this juncture, which is quite unfair.
Counsel, what do you say to that?
first of all, we did not bring ourselves into these proceedings. They joined us as an interested party. The application is directed at the respondent, not at the Attorney General. But the Attorney General's role is to promote rule of law and public interest. And I'm going to speak to the rule of law and public interest, and I'm not ambushing counsel. If I say anything that she needs to respond to, she's here, she'll respond. She has not finished. If she needs time to file further submission, she can file further submission.
No, I will not allow that.
Yes.
So
So my lord,
that will derail this process.
yeah, my lord, I'm going to speak for 1 minute, just on public interest.
I've not allowed you to. I'm
if I'm
listening
allowed,
to your response.
if I'm allowed, my lord.
Yes.
So the objection is misplaced.
On brief rejoinder, my lord, the Attorney General says the role of the Attorney General is to uphold the rule of law, yet they are on record as being on the opposite side, supporting the respondents when it comes to compliance of court orders. You see, their participation is going to be substantial. It's not a general rule of upholding rule of law issue. So for that, we have to object. Number two, this goes to the issue of fair hearing. Yes, there might be parties and there are other parties in the case, but if they wanted to participate in the application, they should have upheld our right to a fair hearing by participating actively, filing the responses, so that we know the accusations that face the petitioners in good time and prepare. So for that reason, we have to object.
Counsel, I'm afraid I have to deny you that right now because you denied yourself the opportunity, so that we don't complicate this matter. Since you had
Maybe the court could have listened to what I've said.
no, I've
then-
listened. Can you sit,
then-
counsel? I've heard you. I'm making a ruling that the AG Okay, so we simply denied you this opportunity, especially because you already told the court you have aligned yourself to the respondents, and that you chose not to file any submission, so it's unfair to let you speak at this point, and so let us conclude the matter.
All right, thank you, my lord. There were quite some issues raised, so let me try and rush through them. The first issue that was raised was the issue of the burden of proof. And we just want to submit that we've been able, beyond any reasonable doubt, to prove that the work is being done, the work of Facebook content moderation for African languages, African native languages, is being done. It is not being done by the petitioners, and the petitioners' contracts stand terminated. Now, the first and second respondent brought up the issue of the orders being impractical, overly broad. Which orders? Which orders were these that were overly impractical, that were too broad? Did they attempt to comply with any of the orders and find it impractical? Or was this a boardroom decision that they will not comply? So then, when the other issue, my lord, the next issue I want to do a rejoinder on, is when the first and second respondents say it is disingenuous to ask the directors of a company to be cited for contempt. I want to point this court to Article 3 of the Constitution, that every person has a duty to respect and uphold the Constitution. And Article 260 defines person to include companies. And part of respecting the Constitution is respecting the authority given to this court by the Constitution. My Lord, our role as lawyers is...
I would object to that line of, first of all, a learned colleague should be responding to issues of law and not anything else. Secondly, she cannot raise a new issue of law at this stage. If she wants us to argue the Constitution, she should say that and we'll be quite happy to respond to it. But she cannot at this stage come up with all these wild ideas on the Constitution.
Yeah. So just be narrow to the point.
Yes.
We don't waste time now.
Okay. I've even
Been
divided
sitting here
it.
long enough. So please.
All right.
Let's respond to points of law which are not clear. I remember today just highlighting.
Yes,
We're going to do the hard work of going through the submissions and everything.
absolutely.
So just bear that in mind. So don't gild the lily.
I'm trying to just go point by point as quickly as possible, but you'll agree there is so many issues. That's the issue.
Yes.
So now there's another issue that was raised about the orders not being specific to the first and second respondents because they had no role to play.
Not specific to first and second.
Because they had no role to play in the redundancy. And my Lord, the answer to that is simply that issue has been settled by the 2nd June ruling. And we need some fact checking on that ruling of 2nd June. Just for a little while, my Lord, there is no stay order with regards to the 2nd June ruling. What exists, or what existed, is what Justice Ongaya referred to as status quo ante 2nd June. So there's no stay. There's no stay of execution. There's no stay order.
There is no stay order
With regards
with regard to
the 2nd June ruling.
Yeah.
What is there is what Justice Ongaya on 2nd June said a status quo ante for 14 days. And then you came back from leave,
Yes.
and because the issue of stay was being actively discussed by the Court of Appeal, you opted to extend that status quo order, not stay. Those are very different orders in law. And then on the 31st July, we were before you to inform you of the outcome of the Court of Appeal stay applications. And we asked you to lift the status quo that was in place. And I quote, my Lord, your words were, the status quo never made sense because the order of 21st March was always in play. Now, where things got complicated.
But my friend shouldn't have this to go a second bite of the cherry. I mean, it's quite obvious. If these submissions have been put down in writing, if she wanted to make these statements, she should have made them in her written submissions. What she's doing now is getting a second bite of the cherry. She's making a speech as to what happened.
Yeah, but with that argument on whether on a stay, whether or not there was a stay order by just my brother judge, extensively argued on himself.
No, I think the argument she is saying that the status quo order wasn't a stay. Fair enough. But to go further now and to make a speech as to when you went on leave and when you came back and what that really isn't what this is supposed to be.
The concluding,
And
where we are at with that.
The least she could do, or the most I should say, is just draw attention to the order itself.
I agree. Let us be brief, Nancy.
I know, my lord. You see, the thing
I
is,
have gotten the point that there was a status quo order in place, and in fact that is what it was, and not a stay order, as far as you know.
that is not the end of the point,
that,
my
and
lord.
It's true that
Yes.
You came and reported the status after the Court of Appeal and dealt with the matter. So, so what is
Where I was headed with this, my lord, is that you actually dismissed the status quo. However, we told you we were going for mediation. So the final orders you made that day were with regards to mediation. So let me make my submission.
No, with respect.
So this is information on record. So the clarification we need. Yes. Yes.
that your response
Yes.
is not on fact.
Yes, my lord.
So we avoid all this controversy.
Yes.
It's very limited to points of law
Yes.
which are not clear.
Yes.
And that's why you have only 10 minutes to do that. So don't engage on facts. Just if you think there are no points of law which are not clear, leave it. Focus yourself on
the
any
points
point
of law
which is not clear.
Very well, my lord.
We will, whatever you said before, we remember. What they have said, we also remember. But most importantly, we'll take a lot of time to go through the submissions, which are already filed.
Yeah.
So don't.
Yeah. I think what I was trying to say, my lord, is that that point needs clarification where the order of 2nd June stands, because clearly the parties do not see eye to eye on that, and that has legal implications. That is all. So the next point, my lord, is the first, second, and third respondents have gone into detail of how they sought clarification. The point of law here is they were asking the court to do something that this court has no jurisdiction to do. This court has no jurisdiction to give any subjective interpretation of a court order once that order has been issued. And that is supported by the authority number 9, where if the order is clear, the court washes its hands, cannot even be called upon to interpret the order it issued. The issue raised that the orders have no application with regards to the first and second respondents. Now that goes to a different issue on jurisdiction. Jurisdiction was already challenged before you, my lord.
No, that was resolved.
And it was resolved. Yet in the affidavit and in the language used in court, which is very regrettable, there's an attitude.
Don't get too much into it.
Yes.
Don't think that I'm not aware of this.
I understand,
or
my
that.
lord.
I'm very aware of that.
Okay.
Yes.
All right. Then now we come to the evidence given. They've challenged the evidence given by Mukhtar and Teslin. Can I address that, my lord?
The quality of the evidence.
Sorry?
The quality of
The quality of evidence. Let us go there, my lord. So first of all, there's a huge misunderstanding the first and second respondents have with regard to what the evidence shows on the platform. I believe that might come from not understanding how the platform itself works. MM3 is not just a random picture. It is the picture of a warning imposed on a Facebook post. And that warning only comes when a human content moderator puts it there. But when they challenge the quality of the evidence, first of all, they fail to take account that there are certificates of authenticity that were already filed with regard to that evidence.
So you filed certificates.
Yes, they are dated 23rd for Mukhtar
23rd
of May 2023.
for Mukhtar, and I think they are also
And
referred-
Teslin is also dated 23rd. It's dated 22nd, sorry, 22nd of May. And those certificates also include the details of the devices, electronic devices. So they pass the legal standards.
That evidence is admissible.
It is completely admissible. There's been no objection to that evidence, no contest whatsoever. All right? Then there's an issue of what conduct is in question in these proceedings, and a court order is valid until it has been dismissed. So any conduct after 21st of March to date is in question here. Then there is the issue of the affidavit by Ms. Redmond and its admissibility in Kenya. What the first and second respondents failed to take into account,
Evidence by?
Ms. Redmond, is that for an affidavit to be admissible in Kenya, it has to be a proper affidavit in the country where it is notarized first. So that then, if you do not follow the rules of the country where the affidavit was notarized, it is not an admissible affidavit in Kenya. And to this, my lord, we point you to the district court rules. The district court rules of the Republic of Ireland, authority number 4, in the bundle dated 28th July 2023.
Number 4 of
The bundle of authorities dated 28th July.
so that's 20.
Yes.
That's where the issue is raised.
Yes. And then now we jump to the issue of, you know, what Council Omino referred to as creative arguments. The issue of terminating a contract twice termination, and the paragraph he referred you to, where the proviso being given by the judge was that only if the first termination was complete.
Yeah, I would say that that's a lengthy judgment which I will read.
Yes.
Because it has become contentious.
Absolutely.
So you just read it to me. I've noted that.
Can I just point you to a point?
Just say what you're
Yes.
saying.
That is exactly the point. The redundancy process is not complete. We are in court so that we get a determination on whether the redundancy is to go forward or not.
It's not complete.
Yes.
And so effluxion.
So it doesn't arise.
Effluxion does not.
The effluxion doesn't arise. So when we are in court now, we are held by what Ibrahim J held. We just obey court orders.
Okay.
Then he raised the point that the effect of the court order was to stop the redundancy. What I want to clarify, my lord, the effect of the order is to restrain the parties from proceeding with the redundancy until the court has made a final determination on it. And he went into great detail discussing the orders that were not issued. Yet, my lord, what we are before you for is the orders that were issued, which have to be read as a whole.
The order which was not issued was order. There's something about order. Is it G?
Correct.
Yet, we are claiming contempt for the orders that were issued. And the question I'll pose to this court, my lord, if the court ordered for the work to continue and for the work to be done by none other than the petitioners, was the work to be done by ghosts? There's a reason why the court said do not terminate the contracts, and that was for them to continue doing the work. Then there's the issue of partial compliance, or what they say good faith compliance. unfortunately, my lord, as per the law and as per the precedent set in Shimas, the Court of Appeal case in Shimas, is that you comply fully with the court order, and then you raise any protests that you might have after compliance. After you have complied to the maximum, that is when you raise the defense. You do not do partial compliance. Then there's the issue of...
It's here. 10 minutes remaining. You must be gone now. Finalize.
Sorry, I wasn't there. There's the issue of the automatic expiration that was also brought up, that automatic expiration is not termination. However, what we submit, my lord, is that the option of automatic expiration was removed on 8th of February. Because on 8th February, there was an actual termination letter that said this is the actual termination that your contract is going to face. It is also regrettable the attitude that the third respondents have taken, that the work was so toxic, so we decided to disobey the court orders. The Constitution guarantees the right to work, and it also guarantees the right to fair labor practices. So that is a very regrettable approach. So their notice, send them home.
Let's stick to the law so that we don't cause...
My God, my lord, the right to work is an issue of law. The right to work is an issue of law. Mr. Omino raised it. So the solution to people being affected by dangerous work is not to deny them work, is to provide care for them, and that is the basis of this case. Doesn't mean that you fire them and you continue torturing other workers. That's not what the law provides. My lord, when you retire to look at the orders, we will just reiterate that it is important that those orders be read as a whole, not the piecemeal interpretation that counsels for the respondents have tried. Again,
Saying read the orders as a whole.
yes, read the orders as a whole. That is the standard set in law. You don't read orders piecemeal. You read them as a whole. And then the issue with regard to the settlement emails that were being offered by the third respondent, my lord, I need to clarify that that was an issue of professional ethics. Both parties...
Now attacking him personally, so I have to interject.
Not
That email
you.
came from the employer.
Not you.
Not from council.
Counsel, I have no
Professional
qualms
ethics
with you.
Is a council issue.
Counsel,
Not
I have no qualms with you. I have qualms with your client, which is all parties were represented by counsel. If it was communication in good faith, why did it not follow the proper channels? And number two, why did it come with a condition that the petitioners had to give up their right under Article 22 to pursue any other?
Okay, we'll leave it there.
All right.
Should have been done through council.
There's now the issue of the fourth.
That's what you are saying.
Sorry, it should have been done through counsel, it should have been done in good faith, and there should have been no condition to give up their right to ever sue. That was the issue with the settlement option. So the issue with the fourth respondent saying that the order was not directed at them.
Okay, fourth respondent, finally.
Yes, the fourth respondent saying that the order was not directed at them, so they cannot be caught by it. They cannot benefit from breach of a court order and get away with it. The party that induces breach of a court order is also as guilty. So they admit that they continued hiring because according to them, the interpretation of the court order didn't bar them from recruiting.
Order G.
And on that basis alone, they were breaching the court order, which stopped engagement of content moderators. The engagement here meaning the whole process, onboarding, training, any part of it. My final comment, my lord, is that when you step back and look at this in context, you will see that this all rises and falls with the first and second respondent.
With respect, my lord, I've said this again and I say it again. My learned friend isn't given an opportunity to make another speech. I think she should respond to the issues of law that arise from the submissions made by the other parties. Otherwise, she's getting
Okay, finally,
undue.
she said finally.
I'm saying finally,
Well,
and the
she
issue
said
of law I'm
finally many
raising
times.
here,
Please, finally.
the issue of law I'm raising here is the issue raised by Justice
Thank you.
Ongaya, which is that the first and
Yeah,
second
get-
respondents
get
are
the
the
point
primary
of law.
employees.
Point of law, you don't do that.
It is a point of law.
Cause
It's not a point.
controversy.
My lord, it's not even
If
a
it's
factual
not a
issue.
Point of law, don't.
I think she just wants to make a speech.
Don't
my lord.
insist on it.
That's what she
Cancel it.
wants.
Let's find it.
Yes. So when you step back, my lord, I hope what you see is that all this begins and ends with the principle. The law of agency comes key here. The principle breaches court orders, and that motivates the agents to continue breaching the court orders, and that becomes a vicious cycle. And the insistence by the principal not to obey the court
That's
orders
it.
has
Could
repercussions.
you respond to
That
that, my
is
lord?
the end of it.
Thank you, my lord.
My lord, just before your lordship puts your pen down, my learned colleague, Mr. Yango, mentions the sections of the Evidence Act, which probably didn't mention them, which was 68, 65.5, and 106. I think she said
That's
106.
on electronic evidence.
Yes, yes, my lord.
These are sections.
I said 60.
The sick is what?
I meant 65, 8,
65,
8 and 1.
65, 8. And
And 106
One is-
to 106I. So it's
106.
106A to 106I. That's what I meant. Yeah.
106A.
I.
I.
A.
A.
106A to 106I.
106I.
Yes, my lord.
Okay. All right.
Thank you, my lord.
Audience, I'm calling you for the industry, the patients,
Thank you, my lord.
including myself, for being
Thank you.
Yeah, it's almost 3 o'clock. Yeah. And so it's a roaring date. Actually, it's by coincidence, I'm on leave from tomorrow.
Oh, really?
Yes.
Enjoy your leave, my lord.
Yes, exactly. Until the end of the month. So I'll be back on the which date? First of no, December. So we're back in December. We are doing judgments. When are we coming back? In December. Which is the first day? Okay. Is the 6th? Is the 7th? Yeah, so I will have time to do that on leave and deliver your ruling on the 7th of December. December.
My lord, can I just indulge you, and please do not run out of patience with me, but I think there's been a subsisting urgency of the situation with the petitioners, and it would be good to just know what the way forward is, just for their own safety. And before you have indulged us with the jurisdiction application where you issued the judgment while you on leave via email, is it possible to indulge us in that manner in this one, where we receive it in the month of November?
I don't think so. I've got too many judgments I'm writing. Unfortunately, we take leave, which is official leave, but to do judgments. And I have so many, actually, which I'm going to be doing almost on a daily basis until when I come back.
All right.
That is exactly what happens when we are on leave.
Okay, my lord.
So 7th December. Just be patient. It's just 1 month.
Very well, my lord. Can we also ask that we get clarification on the second June order?
Which one?
On whether the status quo is in place or is not in place. And we just get clarification as well.
What?
It's already on page 90 of the type proceedings. It's very clear.
It's already there.
It is. If the council has the type proceeding, I can share.
It is still in place.
It is.
I have the order of 14th of June in writing. I can provide it to
No, I'm not talking about 14th June, I'm talking about 31st. By 14th June, we didn't have the Court of Appeal decision which had dismissed the stay, and you had put in place the status quo, waiting for the decision of the Court of Appeal, which now dismissed the stay applications. There is no live stay application in any court whatsoever with regards to the issue of enforcement of
Of
orders.
course, the orders which are the subject of this
Yes,
have not been discharged.
they have not been
They are
discharged.
still in place. That's why we are here.
Yes, my lord.
So those interim orders are still in place.
Yes,
And I should say so. They were on which date?
the ones for 21st March.
21st March 2023 are extended. So remain in place until the matter is resolved.
So what becomes of the other interim orders that were confirmed?
Council herself relied on authority. Which one was it, Council? The one which says that a court cannot be called upon to interpret.
There's no order that was given. There's no order that was given. That is where we are at. So what I'm asking, my lord, is as you make the ruling on the issue, on this issue, to give clarity on where we stand.
You see, the inter-parties hearing by Ongaya J
Yes,
was either the purpose for that was either to confirm or discharge the
Yes.
order, the interim orders,
yes,
which are still in place.
yes.
So they can be different from what I had issued myself. So the effect of that proceeding was to either to
Confirm or set aside.
Yes.
And they're still in place to date. So I don't consider that whatever happened in 1st June changed what we had ordered. And that's why all I needed to do is extend the orders which I issued myself.
I think the issue is that the orders for 2nd June were more extensive, and there were positive obligations, for example, to the government. And we would like for those orders to start taking.
And they are in place if they were issued.
All right, thank you.
Malala Collins shouldn't seek legal advice from the court.
Yeah.
You should just go and look at what there is.
It's okay. I think as you should also, if you have the copy of the record, I think that Omino is saying, I think that should be more clear. Because whatever is in place remains in place unless set aside.
Thank you, my lord. That is
Yes.
all the clarification needed.
Okay. Thank you. Then we'll see you.
Straight from the
Thanks, my lord.
Thank you.